Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. The first case on today's docket is In Re Amendments to Rule of Civil Procedure 1.510. I'll first recognize the Assistant Solicitor General.
Thank you, Mr. Chief Justice, and may it please the court. My name is Jason Hilborn for the Florida Attorney General. The Attorney General supports this court's adopting the federal summary judgment standard for Florida summary judgment standard. But we submit that more needs to be done for the effective implementation of that change. And that involves expanding the timing requirements of the rule. The rule allows the party opposing summary judgment to wait until 2 days before the hearing to file brand new evidence with the court. This evidence includes newly disclosed affidavits inserting new facts into the case for the first time. 2 days is not enough time for the movement's counsel to evaluate that evidence and prepare a reasoned argument for the judge at the hearing. It's also not enough time for the trial court itself to prepare for the hearing as well. And preparing for the hearing is critically important in Florida courts because the trial court frequently will rule on the motion for summary judgment from the bench at the hearing. But even putting the hearing to the side, 2 days does not provide enough time for the movement's counsel to have discussions with their client and for the client to have internal discussions about whether it makes sense to move forward with summary judgment at all in light of the brand new evidence that was filed, or whether settlement discussions should be pursued. But there's no time for that right now in Florida courts. Instead, the rule prompts a 48-hour fire drill for everyone to evaluate the evidence as fast as possible and try to put together some sort of coherent argument for the judge at the hearing. There's no need for this rush, and it's not allowed in the federal courts. So in federal court, the default rule is that the party opposing summary judgment must file its opposing affidavit 7 days before the hearing. But in reality, it's often much longer than this because what most federal courts require, including the federal courts in Florida, is that the party opposing summary judgment file an actual brief in response to the motion, along with their opposing evidence, some amount of time after the motion for summary judgment has been filed. So in the northern and the middle districts of Florida, that's 21 days. And in the southern district of Florida, it's 14 days. We propose something similar, which is that this court extend the time required for the movement to file their initial motion from 20 to 30 days, and then require the non-movement to file an actual brief in response to that motion, along with their opposing evidence, 20 days after that. This does a couple things. One, it creates at least a 10-day buffer from when all the evidence is submitted to the hearing for everyone to catch their, evaluate, and make sense going forward. If it makes sense still in light of the new to continue with, then there's prepare for the summary judgment hearing. The second thing this does is require the non-movement to file an actual response brief, which we think is important because that lays out the case law and the legal arguments that are going to come up at the hearing. And I think our goal here overall is to create the greatest opportunity for everyone involved, including the court, to be prepared for the hearing. And with that, I welcome any questions this court may have.
All right, well, we thank you, Mr. Hilborn, and I'll next recognize Mr. Carr.
Good morning. May it please the court. Thank you for having me, and especially thank you for giving me 10 minutes. I view this a rule change as a reduction in the right to a jury trial. Even the smallest reduction of the right is an infringement upon that civil right to a jury trial, especially in our present times where our civil rights are really under attack. The right of free speech is under attack. The right of association is under attack. The right of religious freedom, gathering together, is under attack. With the pandemic is always the stated justification. So I don't really understand why we're doing it at this time.
Mr. Carr, if I could, I'm just struggling to understand that point. If the standard that we're adopting is the same as a directed verdict standard, that means that you could impanel a jury and go through that entire process, but the case wouldn't be given to a jury. So if the standard is the same, I'm just struggling to see how you're doing anything like declining someone the right to a jury trial.
Well, I think you're declining them the right to certainly start the jury trial.
But I mean, isn't that meaningless? Do you think clients should spend money starting a jury trial in a case where the case would never be submitted to the jury? That just, I'm having a hard time understanding how that would be good for the efficient and effective administration of justice.
Well, with respect to the efficient and effective administration of justice, efficiency, speed, convenience, expedience, all those words, some of those words were used by the court and some of those words were used by the my opponents or those proponent in favor of the rule. All that does come at a cost. And the cost is the denial of the right to jury trial. Now,
but you're talking about a case in which the case would never be submitted to the jury to decide. You understand that, right?
I understand that. And okay. I read the court's opinion and I noted a couple of references or citations to the court's opinion in the court's opinion on page 4 when you talk about the article written by Berman and Webster, where you say that they criticize the present standard by saying that any competent evidence, credible or incredible, substantial or trivial, whether or not evidence is credible or incredible is really a subjective interpretation, or whether or not evidence is trivial or substantial is a subjective interpretation. So you're taking that interpretation of evidence and you're putting that on one person, on the judge. The evidence has an application, an interpretation, and all the inferences that are gathered from that evidence. If we have a jury trial.
So Mr. Carr, are you suggesting that we should do away with directed verdicts?
No, not at all. Not at all.
Because the judge is still going to make the decision. The question is whether the judge makes the decision after we go through the time, energy, expense, and effort of bringing citizens into a courthouse, having them sit there and ask them questions about whether they're fit to hear a case that they won't actually hear, and then sit in a jury box and hear evidence until all the evidence is presented, and then the judge will say, no, the jury can go home. I mean, that's what you're suggesting is a better approach.
Well, that's a more informed approach. When you have a motion for summary judgment, you don't have the full context of the case. Principally, what we're talking about when in my experience, I think most trial attorneys will have, is you get to the point with summary judgment where you have depositions and documentary evidence. I'm not really talking too much about documentary evidence, but when we talk about depositions, we're talking about testimony that has been taken by the adversary, often it's the client himself. So the adversary is using leading questions, and he's got the adversary, he or she, has an agenda with their questions. And I mean, we don't try, and usually in most instances, the plaintiff or the non-movement doesn't jump in and put on their whole case in a deposition. Nobody wants trial by ambush, but at the same time, nobody wants to tip all their hand in the deposition, certainly defending a deposition. So you've got a slanted and tainted collection of facts in a deposition that are being presented to the court without the full context of the case, where the particular piece of testimony that might be focused on, or the particular statement or concession made is not being given in a full context. And once the plaintiff doesn't have the chance in a deposition, nor would he really want to if he's expecting, and I'm assuming that we're talking mostly about defendants moving for summary judgment. That's why I'm using the word plaintiff, where the non-movement isn't going to be wanting to put on his entire case. Well, with in a deposition or pretrial, because that's for the trial. The trial is where we lay out the whole case, the context of the case. We present a story.
Counsel, I understand the tactical advantages you're talking about, but I'd like to connect it to the argument, or try to connect it to the argument we're making. Our opinion holds that the federal summary judgment standard satisfies constitutional muster. Can you direct us to any case holding that Rule 56 unconstitutionally violates the Seventh Amendment jury trial right in civil cases? Because you began by saying that our adoption of this was an infringement on that liberty, one we take very seriously. But I think you'd be hard pressed to direct me to a case holding Rule 56 unconstitutional as a violation of the Seventh Amendment jury trial right. Can you surprise me? Do you have something up your sleeve?
Well, no, nothing up my sleeve, but I would cite to Article 1, Section 21 of the Florida Constitution, which gives the citizens the access to the courts. And when we're talking about
has any court interpreted that provision to hold Rule 56 as problematic in the state of Florida? Or is there any Southern, Middle, or Northern District of Florida case law holding that that provision of the Florida Constitution, the right of access to the courts, is somehow denied by the federal court standard of summary judgment?
Well, we're talking about a federal rule applying to a state constitution. I'm not aware of any case, and I would think that would be a rare situation where the federal rule would be applying the Florida Constitution.
I think we would have heard,
but I'm not aware of any case.
I think we would have heard the argument that somehow the Florida Constitution preempted or made it problematic for access to courts by now. Don't you agree?
Well, we're talking, no, I don't agree, because you're talking about limiting a right. The Florida Constitution, I think access to courts gives our citizens actually greater rights to the access to courts through a jury trial than would any federal statute or federal jury trial right. We as a state have the power, the court, the legislature, the governor, have the power to give the citizens more rights to a jury trial than the federal.
That much I understand. I guess I'd like to hear how you think it restricts access to courts then.
Well, I think it restricts access to the courts because it gives the trial judge a chance to make subjective interpretations about evidence, whether or not something is evidence, right? Or whether it's the Massachusetts case talked about whether there's a metaphysical doubt, and the Anderson case talks about whether the evidence is merely colorable or significantly probative. And the Scott versus Harris case talks about whether or not a reasonable jury could make a determination on a particular issue. All those things are subjective interpretations of an individual, a human being that is applying their view of the evidence submitted by an adversary with an agenda before the plaintiff has had an opportunity. And the infringement is that it gives the judge the subjective.
Mr. Carr, your time has now expired. I'll give you another 15 seconds to sum up.
Well, I think that's it. I think the only other point I would say is, why are we here today? We're talking, on Zoom to see facial expressions and everything. A motion for summary judgment is black and white. Communication experts agree that 70 to 93% of communication is nonverbal. At a trial, you're going to get nonverbal communication. You're going to see how the parties react to statements, and you're just never going to get that in a motion for summary judgment. It's just black and white paper, and it's really not a full presentation of a story of a case.
Okay. Thank you, Mr. Carr. Ms. Berman.
Good morning. May it please the court. My name is Cece Berman here today on behalf of the Civil Procedure Rules Committee. The committee got together at this court's invitation in its recent opinion to consider three of the questions that were raised by the court at the end of its opinion. First, whether any additional amendments are needed to Rule 1.510 beyond what this court has already adopted. 2, whether there are any textual provisions of Rule 56 that ought to be either adopted or imported into 1.510, or whether Rule 56 just ought to supplant Rule 1.510 outright. As we've shown in our comments for the court, the committee suggests the answers to those questions are: number 1, yes, additional rule amendments would be helpful to the litigants and to lawyers in the state of Florida. Number 2, we do think there are some provisions in Rule 56 that would be helpful to bring into Rule 1.510. But 3, no, the committee does not believe that it is appropriate to adopt Federal Rule 56 outright and essentially demolish Rule 1.510. The reason that the committee, jumping right in, believes that some additional change would be helpful would simply be to provide some more concrete guideposts to litigants in Florida. Although the court's already gone a long way by adding the additional sentence to subsection C of 1.510 in reference to the Celotex trilogy, it's certainly true that U.S. Supreme Court cases are a bit dense, and it might be helpful to litigants, trial judges, lawyers, and perhaps most importantly, pro se litigants who use our rules all the time, not trying to tackle a body of case law when they're looking at the summary judgment rule. And if we could perhaps just put some procedural guideposts in place, that might be helpful. In fact, along those lines, Federal Rule 56 itself was amended after Celotex came out. There's also a practical reason for this change that the court might not have had an opportunity to consider, and that is in Rule 1.510C. It says that a motion for summary judgment movement must identify the evidence on which the movement relies. And I think under Celotex, that might not necessarily be so. And that's why Rule 56C1B was amended post-Celotex to reflect and recognize that you don't always need to point to specific record material. So we think there might be a little additional cleanup to be done. Now, the committee's recommendation, as we put forth in our comments, there's quite a spirited debate beyond that within the committee about what should be done if this court is inclined to do anything further. Is it to bring in parts of Rule 56? Is it to adopt 56 outright? Our members often jump back and forth on that question. There's certainly pros and cons to each. But at the end of the day, by a vote of 21-16, it is the committee's position that this court do some additional amending of the rule, but do it in a measured approach that is essentially this. With some minor variances to account for state court procedure, it's the committee's suggestion that this court dispose of current subsection C of Rule 1.510 and essentially replace it with subsection C of Federal Rule 56.
I'm sorry to interrupt you. Can I ask you a question?
Yes.
So first of all, I just want to say thank you to you and to your committee. You guys do a ton of work, and I know that there was a really short time frame on this one in particular, and it's obviously a big change for our state, and you guys did a really thorough job, obviously, of considering all the issues and giving us both sides and everything, which I know that everyone on the court really appreciates. So as far as the issue of the adopting Rule 56 almost entirely versus making the change that the majority recommends, assuming that we were to retain tagging timing to a hearing and maybe adjusting as the AG has suggested, and as I think everyone on your committee kind of suggests, building in more time. I understand sort of the argument of, look, this rule's been around for a long time, let's be more incremental or whatever. On the other side, to the extent that we really do want to do everything we can to, change not just what's on paper, but actual, outcomes in terms of how things actually work. I don't mean outcomes in particular cases, but in terms of, people actually applying, the new standard faithfully. It seems like there's a strong argument for, just using as much of Rule 56 as we can. Could you give us specific concerns that would sort of push you in the direction of wanting to keep as much of the current rule text as possible? Because I understand the argument of like, we don't know what we don't know. But is there anything, specific that that emerged from your discussions that you would want us to be aware of?
Yes, Your Honor, in fact, and I think that's why a lot of the committee members, me included, although I don't get to vote within the committee, kind of flip back and forth because it is very attractive, to be frank, to consider just pulling in Rule 56 outright. But here are a few of the examples that we saw. For instance, there's case law in Florida interpreting subsections D and F of Rule 1.510. And I apologize, I admit I don't have the case law here with me today. I didn't think we'd be getting quite into that level of detail, but it's out there. And meanwhile, on the federal side of the coin, we've got Rule 56F, which talks about being able to enter summary judgments independent of the motion with no state court corollary. Or we have Rule 56D, which addresses what happens. You can make a 56D motion when there are facts not available to the non-movement. We don't have that in the state rule, although we do have some Florida case law that discusses that. And I think what the committee, and thank you for recognizing the time crunch, we actually tried to start going down some of these trails to see, well, will it make a difference? How much of a difference? And it honestly got to be a bit overwhelming. What became clear is there is quite a bit of case law out there, perhaps more than any of us realize, tagged to different subparts that don't really have anything to do with this court's adoption of the federal standard that could be impacted, and maybe it would be all right and maybe it wouldn't. And there were just too many rabbit trails for us to follow up on completely. And I think what became telling for the committee is among the supermajority of states who have adopted the federal standard, I believe the answer is none, but I don't want to mislead the court. If it's not none, it's close to none of them have adopted Rule 56 outright. And that was a survey that the subcommittee looking at this rule undertook at the outset. And it appeared that other states had similar concerns. And so to varying degrees, they have parts or more, more or less than others of Rule 56 in them. But it turned out that we might not be the only ones with that concern. So our thought was, over the long haul, if that's something this court would like to do or entertain, we could certainly talk about that. I will say that within our own committee, I think that you will find that it's pretty much agreed among the committee as a whole. There's still some additional cleanup just to make our rule look a little better, setting aside the change that this court has effectuated in its opinion, just from a pure crispness of the rules standpoint. But at the end of the day, there was enough there that I think more time. This is something that normally would take months. I can tell you that folks put in so much time only to unearth more of these questions and what would happen. And we anticipate that litigants will be relying, and certainly on federal case law as a result of this opinion. But we do still have our Florida case law, and we do still have situations that will arise no matter which standard we're working under that might still apply and to whatever situations might occur. And we won't necessarily be able to address it as well. So it just seems.
I'm sorry to interrupt you. Could I ask you
Yeah.
a question? I noticed that one of the suggestions in the Attorney General's proposed changes to the rule involves requiring legal memoranda. And I noticed that at the subcommittee level, the majority of the people on that subcommittee, it was like 8-4, 7-4 or something, thought that requiring legal memoranda was a good idea. But I don't think that that's in either the majority or the minority proposed text, is it? So do you have a view on that? Or
No, in fact, Your Honor, I noticed the same thing as I was preparing for this, and certainly I was involved personally in a lot of what went on. And I think at the end of the day, the majority proposal that we've put forth is requiring a response. And I have to come clean and tell you that I just can't recall for the life of me, and I couldn't get anyone on the phone yesterday to ask them what the differentiation was that the subcommittee was making when it talked about legal memoranda versus response, because certainly the proposals that have been put forth by the committee are anticipating responses from folks who are the non-movements, for sure.
okay, do you think it would, and I think the AG's thing sort of said, something about having a brief addressing the legal issues from both sides. I mean, as opposed to just saying response, I mean, do you think that there would be value or any downside in being more specific about that?
So I'm speaking just for myself, frankly, here at the moment. I don't think so. I can only, in my own practice, I prefer that. So I think no, I'm a little hesitant I've tried to be very careful with this being an issue that was so robustly debated, to present everything on behalf of the entire committee I'm here representing. But to me, there's nothing offensive about that proposal that you're suggesting.
Okay, thanks.
Thanks. So at the end of the day, I think, we did just cover quite a bit in that discussion about why it is. And in fact, I was going to jump into some of those examples for why it is that the committee is suggesting instead this importing into Rule 1.510 subsection C. And then if it is something that the court wants to look at more broadly, then let's do that. But I don't think that, and the committee does not believe this court can implement its opinion by making this more measured change, and it will be implemented. And that seems to be exactly how it's done all over the country. And from what we found, folks aren't stumbling and having trouble implementing the federal standard when they do it that way. But if they're still concerned, there's nothing that would prevent, of course, further amendment to the rule to allow time to consider those other issues.
I think as far as it seems like all the commenters seem to agree that even if we were to quote unquote adopt Rule 56, there would have to be these kind of variations for the timing and the fact that it's tied to a hearing as opposed to, the way it is in the federal system. So, if someone were doing if we did that and then someone did a search, 3 months from now, Florida would be in the column of states that haven't adopted Rule 56, or that people would point to Florida as not having done that. So I guess, and I'm not being critical because I understand the issue of the unknown unknowns and all that. But it just seemed like the concerns about adopting Rule 56, and it seems like everybody, I don't think the existing rule is going to win any awards for, clarity or writing or whatever. I think everybody agrees that if we were writing on a blank slate, Rule 56 is better written, it's more direct, it's whatever. It just seems like the concerns about moving to that are more kind of speculative than really concrete. And I'm not trying to be argumentative or whatever, but
I understand, John, and I think the committee would acknowledge that some of the issues we've raised may turn out to be non-issues. As I said, we tried to start running them down and it just got to be difficult. But there are some things that I think that might matter. I'm taking a look here at some of my notes for what we've got. I know that Rule 56F, for example, was one of them that raised quite a bit of discussion among committee members, the ability to enter summary judgment independent of the motion. That's a pretty significant change, and yet it was not part of this court's discussion in its opinion, and is not part of the Celotex discussion.
Right, and I understand. My sense from the comments was that's, so the rule says after notice and reasonable opportunity to respond. So it's not a matter of people, just randomly getting summary judgment entered against them. But also, I thought the comment said that basically in Florida that's already something that courts do. Obviously I'm assuming it's not happening, every minute, but it's something that already does happen. So it's just making it more kind of transparent.
Right, and we talked about that a little bit further, and it's true. There's some lawyers who feel that already happens, although the way they describe it is even a little different than I myself pictured it, because I have to admit, I've actually never seen that happen, although my practice is mostly appellate, so I'm not at that many summary judgment motions. Having said that, where some folks said they saw it is it triggers new motions. For example, the judge might say something like, on a duty question, well, I see the duty, but I don't see how you're ever going to prove causation. So summary judgment's denied, and then a new round of motions comes up on causation. So it's not quite that the judge does it right then and there, but the judge injects what he or she sees as the proper summary judgment issue, and then encourages, by way of mentioning that, it encourages everyone to file the next round. I think that's what folks are talking about when they say it already happens. And at the end of the day, the committee is certainly willing to acknowledge that if these are not concerns for the court, they're just not concerns for the court. And that's why we wanted to present both sides of this coin, because like I said, it was something that was very robustly discussed within the committee, with people being, very open-minded and seeing lots of pros and cons either way. So I don't think I would argue too much with you.
No, I really appreciate that. And like I said, I know all of us appreciate all your hard work. And it's really, I think we just want Florida to have the best rule and the best process that we can. And you guys, obviously, with all your hard work have helped, illuminate the issues for us. And we really appreciate that.
Absolutely. We feel the same. And thank you so much.
Thank you, Ms. Bierman. Mr. Meadows.
Yes, sir. Mr. Chief Justice, members of the court, my name is George Meadows. I am arguing here as a practitioner, not representing anyone other than myself. But let me go directly to the point of 1.510 versus Rule 56. The moment that this court might keep intact some substantive portions of 1.510 will be the beginning of arguments all over the state about what that means and how to have both 1.510 and Rule 56 at the same time. Justice Muniz talked about you don't know what you don't know, but what we have is 35 years of experience from Celotex to today's date about specifically how these things act and interact and make good sense. Rule 1.510 is not as well written. It is in ways potentially contradictory. And what Rule 56 does is make it much clearer as to how to navigate that circumstance. Ms. Berman noted subsection F relating to the ability of a court to grant summary judgment on its own. And again, Justice, you said correctly that requires notice and opportunity to be heard. And also, the practical reality in my experience is that a state court judge will often indicate concerns, comments about what has happened so far, with clearly the notion that this might be a case for summary judgment, and I'd like you folks to think about that. At the very same time, in federal court, very good judges here and elsewhere will comment about, I need to know more about this issue or that issue. You may not have been thinking about it, but I have. And what that does is bring everyone closer to an understanding of what the cases are about, what the weaknesses are, and what has to be shored up. To me, that is an excellent example of how the federal rule applies efficiently. And one other thing and I will stop here, is that the notion of a hybrid bill is one where, like I said, interpretation will take over everything else. And one thing about the federal rule that is critical is no more can you just throw 1,000 pages of documents and say, here, judge, look at these and you'll find disputed issues and material fact. The parties have to lay their cards on the table and to tell the judge what is or is not. That's efficient. And with that, I hope to win the shortest argument.
Thank you, Mr. Meadows. See, there are no questions. All right, Mr. Lee.
Good morning, Mr. Chief Justice, and may it please the court, Brian Lee on behalf of Jones Day and Hill Ward Henderson. In addition to answering any questions the court has, I would just like to make 3 points. One of which is I won't dwell on long. The court should stay the course and adopt the federal standard for all the reasons the court's already given, which is especially important now, given the backlog that has developed in light of the pandemic. We need to reserve trial court resources and all that goes into it, to jurors, to the folks working in the courtrooms to make everything run, to the parties, should be reserved for those cases warranting a trial because they have a factual dispute. How to implement that standard, I would urge the court to adopt Rule 56 in its entirety. There's a few reasons for that, some of which have already been hinted at in questions today. One of which is when you adopt a settled rule, you get the benefit of that stable body of case law. I heard a reference to it earlier being voluminous. That's a benefit, I think, here. It brings with it stability. Much of the claimed uncertainty will frankly dissipate because we're drawing on this stable and well-settled body of law, which raises the second point. There's a danger in listing cases. I'm not suggesting that it can't artfully be done. I'm not suggesting that listing the cases the court has proposed listing, in my opinion, they're best read as incorporating the federal standard. So I do think they do that. But I think in listing a few, you run into the risk that others are perceived as not listed, as not part of the rule the court's adopted. Scott v. Harris has been mentioned by several commenters as a key addition to Florida's summary judgment standard, but it's not on the list. And so I can guarantee that somebody out there will say, they listed some and excluded another. And when you exclude another, you imply that it's not part.
So are you referring to the change that we've made that talks basically lists the Celotex trilogy?
I am, Your Honor. I am. And I'm suggesting that adopting the federal rule as a whole will accomplish that without implying the exclusion of any other.
I guess part of the challenge is, because the problem, Florida and the federal standards have diverged so much, even though the text is the same. The challenge is if you change, you could arguably adopt Rule 56 and Florida courts could interpret it the same way they've been interpreting 1.510. And so the idea behind specifically talking about the Celotex trilogy, which I think everybody would acknowledge is kind of the fountainhead for all the existing federal summary judgment law, was to make it clear that, substantively, that is the standard that needs to govern in Florida, assuming, that we retain the change and whatever.
Understand exactly. And I agree. I think it's best read as doing that. I just think a better way of accomplishing the same goal would be to adopt Rule 56 and maybe move the discussion of Celotex, make it non-exclusive, and maybe move it to the comments as a direction of like, hey, we meant it when we made this change. Another benefit of adopting the federal rule has already been discussed by some earlier people who have commented, is the benefit of some of these other provisions of the federal rule. Some of them, there's widespread agreement that it would be a good thing to require courts to explain the reasoning for their summary judgment rulings. It helps appellate courts when they have to go in and figure out whether summary judgment was properly granted. And frankly, I think it will lead to better decisions at the trial court level because people tend to make better decisions when they have to explain themselves and be accountable on the record. It just focuses in the reasoning process. Similarly, there's apparently some confusion about whether declarations count. The federal rule would remove that. And even some of the provisions that were suggested as unknown earlier are actually important parts of the efficiency promoting summary judgment process. When a judge says this may be a summary judgment issue, if he doesn't address it there, it will linger at trial and render the trial potentially worthless, something that didn't need to occur, didn't need to tax court resources if there's no genuine issue of fact. So better to allow the judge to spot that earlier, and the rule requires that the parties be given a chance to respond. I realize my time is short, so I would add that extending the rule to the maximum extent, implementing it to the maximum extent consistent with efficiency would both promote what the civil rules are designed to do and would be key, as I mentioned earlier, during this pandemic. And in my view, and would suggest that the court should make it clear that it applies to pending cases, even if it requires reconsideration, as this court ordered in Wilson Art. And also, we've proposed some language to do this, make clear that when a case comes back for a new trial or by virtue of an appeal, that the new rule applies there too. Just clarity on the front end so that we don't have ancillary litigation about how the rule takes effect. Thank you.
Thank you, Mr. Lee. Ms. Stein.
Good morning. May it please the court. Dinah Stein on behalf of the Doctors Company and Florida Medical Association. And we have proposed additional language to be incorporated into the rule as your honors have proposed, which expressly sets forth what is required by both sides of a summary judgment motion at each stage of the proceeding. And the reason we proposed more express language in this regard is because Celotex is a plurality, and there is no cohesive statement on what is required of the moving party that is claiming the other side can't prove its case. To the extent that Justice Brennan said, we're not explaining what's required of the initial moving party when it's trying to show that. And in researching how these federal circuits have applied Celotex and how the state courts other jurisdictions have adopted Celotex, there does appear to be a divergence in what's required as far as the evidentiary standard and whether a movant must affirmatively show that the other side with evidence doesn't have evidence. In reviewing the case law, we believe that the 11th Circuit, the United States 11th Circuit, in its Fitzpatrick decision that was cited in the papers, most closely represents what this court is trying to accomplish in its adaptation of Celotex in the trilogy, and making it like a directed verdict motion. The Fitzpatrick case says that the moving party, and this is the language that we incorporated into our proposed addition to the rule, it says the moving party trying to show that the other side can't meet its burden at trial doesn't have to affirmatively prove that. They need to just identify to the court the issue and then place the burden on the other side to come up with evidence, just as in a directed verdict type proceeding, that they can prove their case should it go to trial and withstand a directed verdict.
I'm sorry to interrupt you. And I thought your comment was really thoughtful and I really appreciated it. It seems like the academic debate over this in the case law has to do with kind of trying to find that line between, you know, a conclusory allegation that the non-moving party doesn't have evidence versus, you know, showing that they don't. And it seems like the Rule 56C sort of tries to kind of give people more direction. And I looked at the language that you guys proposed, and it's maybe, you know, elaborates on that a little bit more, but I'm not really sure that, you know, having this frame, I mean, and obviously I'm not criticizing substantively the framework that you've proposed, because I think it does kind of distill what the case law has said on this, but what's the value of doing something like this over and above just having the equivalent of 56C, which kind of, you know, post Celotex and all that has tried to kind of give parties a little bit more direction, more concrete, more of a concrete framework for, you know, showing what needs to be shown.
Right, and the concern is, first of all, that the version of Rule 56 that was in effect at the time of Celotex was much like the Florida rule, and it seems that the rules have proceeded on parallel paths with the substantive law, but not reflecting the substantive law. And if the court were to compare, for instance, there's a Second Circuit case we cited called Nick's Garage, which is applying Rule 56, you know, with the Fitzpatrick case, you know, they come to different conclusions as far as what's required. And so the concern is that Rule 56 has changed since Celotex, but it hasn't changed the substantive Celotex. And I don't know that it's given the courts, you know, enough guidance to really show what is intended to be required for the moving party. The other thing we noticed is in other states adopting Celotex, you know, not all of them adopted necessarily the majority. I mean, some of them adopted, they said Celotex, but adopted Justice Brennan's dissent. So I don't know that just changing Rule 56 or incorporating Rule 56 into Florida is going to fix the problem of what is the burden on the moving party moving for summary judgment under Celotex. That was the concern, is that just saying Celotex, I mean, I think it's
would adopting the equivalent of 56C, does that get you a lot of the way toward accomplishing your objective with your comment?
I think it helps. I don't think it gets us there. And again, because there's been so much interpretation of Rule 56 that doesn't always come down on the Fitzpatrick analysis, which is that expressly the moving party that's trying to show that the other side can't prove its case doesn't have to affirmatively prove that with evidence and run out and take discovery and depositions. I don't know that just an adaptation of Rule 56 would get us there. In other words, I think it would still leave it open to argument and interpretation and potential variance in decisions, which is why, you know, we took this language, which is, I guess, a hybrid of Justice Brennan and the Rehnquist plurality from Fitzpatrick. And this tells the parties exactly what is expected of them. There's no question, there's no interpretation. It lays out a very easy
Ms.
framework.
Stein,
to follow.
you're now about a minute over. If you could sum up quickly.
No, I thank the court for hearing us on this and for giving us the time on this very important issue. Thank you for having us.
Okay, thank you, Ms. Stein. Mr. Geddes. You're muted.
My apologies, Your Honor. May it please the court, Edward Geddes on behalf of Public Supermarkets. I'd like to concentrate my comments, observations on a couple of points. The court has heard some excellent suggestions from the other lawyers who have appeared this morning, and there are certainly a number of good reasons to consider the adoption wholesale of Rule 56. Where I would like to focus my comments is the point that if the court were to decide not to adopt Rule 56 wholesale or adopt only 56C, that the court also consider the possibility of implementing a portion of 56A, which requires the trial court to articulate either in its order or on the record where there's a court reporter present, its reasoning for either granting or denying a motion for summary judgment. And my primary concern, as we expressed in our comments, is that inertia is an extremely powerful force. There may be reticence, there may be lack of confidence in our trial courts to implement the new federal standard. Frankly, it may just be a question of habit for judges who have been on the bench for a very long time and have labored under Florida's slightest doubt standard. And I think requiring this articulation has a salutary effect for all the participants in the process, and including the trial judge, which is to consciously engage how the adoption of the federal standard affects the outcome in this case. When this court adopted recently in connection with Florida Highway Patrol versus Jackson, the amendment to Rule 9.130 to allow for a comprehensive interlocutory review of immunity decisions, the court noted that the previously existing rule perhaps allowed too much deference to the trial courts in how they articulated their position and thereby defeated the purpose of immunity. We have a similar concern here, that not requiring an articulation of reasoning has the potential effect of frustrating the adoption of the federal standard because denials of summary judgment are not reviewable. So the exercise is as important as the outcome in our view. So we think that component, even if the court decides not to adopt the entire rule, the component requiring an articulation of the reasoning of the trial court should make it into the record. The other observation I would make, and this is directed to my friend Mr. Carr's comments about the dangers of resolving cases at summary judgment. I think there's a built-in bias, and I'll speak now generally about the plaintiff's bar, that because of the existing case law that was in Florida and the standard that applied regarding the slightest doubt, perhaps plaintiffs tactically made decisions when they came to summary judgment not to lay out their entire case, not to present all of their arguments. And I think that was just what the prior system engendered. And I think it's interesting, the Sixth Circuit and the Seventh Circuit after Celotex colorfully described summary judgment as the put up or shut up moment in litigation, which is both sides need to come forward. Both sides need to articulate exactly what the evidence is. Does this case merit going to trial before a jury? And if either side fails in that endeavor, well, there are consequences to it. And the bar needs to be alerted to that fact. So I think whatever this court can do to help the bench and bar overcome whatever built-in bias there may have been in the system arising from the prior summary judgment standard, it should do, because that will incentivize all the participants to step up and engage the task meaningfully in a way that lets the court reach the right conclusion. So I thank the court for its time and allowing us the opportunity to speak. And unless the court has any questions, I'm done.
All right. Well, thank you, Mr. Geddes. And next, we'll have Mr. Van de Bogart. Forgive me if I mispronounced your name.
That was perfect, Your Honor. Good morning. May it please the court, Joseph Van de Bogart for the business law section of the Florida Bar. The business law section is comprised of litigators practicing business litigation, intellectual property, creditor and debtors' rights, and bankruptcy, as well as corporate and transactional lawyers. In the past, Florida lawyers throughout the state have routinely lost motions for summary judgment based on an opposing party's unproven or unshown allegations, with the slightest doubt often winning the day. Thus, the business law section applauds and supports the Florida Supreme Court's adoption of the federal summary judgment standard. However, we've provided in our comment that simply citing to the Cellutex trilogy of cases and adopting the new standard is not enough and may potentially lead to ambiguity, uncertainty, and inconsistencies in application by Florida trial courts. In drafting the comment and proposed rule changes, we try to follow what the court had provided in its previous opinion as its reasoning for adopting the rule by making sure it is crystal clear to lawyers and jurists what has been done and how it should be applied. There are two core aspects of the federal standard that have been suggested in our appendix: that the directed verdict standard applies, and that the burden of proof at trial applies to the correct party when providing evidence on a summary judgment motion. The third change our appendix suggests is adoption of Rule 56E when a trial court applies a standard. We think this is necessary and helpful for a court applying the federal standard. We believe we have stayed true to the court's intent in adoption. We simply suggest making it more clear and explicit in the way the rule reads.
I'm sorry, could I interrupt you?
Sure.
Could you elaborate on why you're not recommending adopting, Federal Rule 56 with the tweaks to account for Florida, procedural wrinkles?
Yes, absolutely. The business law section has taken the position that we do not suggest full adoption of Rule 56 in its entirety, if that was your question, Your Honor, and Justice. And that is because the procedural requirements, the history of the state, this is already going to be a difficult transition for many trial courts throughout the state with the 40-year history of Hall v. Talcott, although one that we have argued and believe should happen. And so if we adopt the entire Rule 56 and all of the other intricacies and changes throughout, which have been argued previously this morning, it's going to make that much, much harder. And that isn't necessary to the court's adoption substantively of the federal standard. And so the procedural requirements of Rule 56 don't need to come into Florida to make the summary judgment standard apply the way it should apply. And thus it's a matter of just clarity, explicitity, making it easier for jurists and litigants to be able to know how to argue and brief summary judgments and make summary judgment a better task here in the state and easier applied here in the state of Florida. And thus, going to 56E a little more, we believe that 56E will give jurists the powers required to apply this new rule. In all four subparts, it specifically speaks to jurists and allowing them to be able to ask for more evidence, things that are not shown, ignore them. And it gives that clarity to a judge as to how to apply the new rule and gives them the power to apply the new rule. And so if there are not any additional questions, I'll leave the rest of my time. And I thank you so very much for allowing us this opportunity.
Thank you. Mr. Edson.
Thank you, Mr. Chief Justice, and may it please the court. This has been a long discussion, so I won't belabor points that have already been made. I'm here on behalf of Mr. Chumbley, Mr. Cohen, Mr. Leopard, Mr. Durham, and myself. And I would make 3 points. The first is we agree and we appreciate the court making this important change. We think the critical distinction and the critical alignment is less state and federal and more summary judgment with directed verdict, and I can't improve upon the import of the questions by Justice Lawson and Justice Curiel to Mr. Carr. So we support that change, and I won't belabor the point. I do want to address the issue of the timing, and I believe Mr. Lee touched on this, and some of the commenters did. Well, I think the opinion and the rule are very clear that it should apply to any pending motions and any new motions, including motions for reconsideration in pending cases. I think in the absence of an express statement by this court saying that, we're going to be litigating that in the lower court. So we think it would be helpful for the court to do that. And the final point I will make is similar to the timing issue. And I think, as everyone knows now, because of the pandemic, there's a huge backlog of trials in the lower courts. And we think now is it is incredibly important at this point, particularly that the court implement this change as expeditiously as possible, so that we're not, harkening back to what Justice Lawson said, we're not using rare and jury trial time, not to mention the people who were the jurors who were involved, but the jury slots on cases that aren't going to get to the jury. And so to that extent, our overall proposal here is less is more, to the extent that you can get this implemented by May 1st. There are a lot of, I think you sort of shook the bushes, and there are a lot of very strong opinions and interesting ideas on Florida summary judgment practice. And I think this has been, if nothing else, a very useful exercise, probably, although I'm sure Ms. Berman would say it wasn't a lot of fun, it's been very useful for the Rules Committee. I think I personally, just speaking for myself, am very supportive of the AG's proposal of going to 30 days and then 20 days. I think the idea of putting in Rule 56C so that you're clear on what actually has to be done to support or oppose a particular fact are important. And to the extent, and I also agree that cleaning up the issue of making sure declarations are also included, as I think the statute makes clear, are good changes. And so we would support those to the extent the court believes they can do them and do things between now and 22 days to May 1st. But our larger submission is, if you're struggling with some of these technical issues to implement them, our proposal would be to implement what you have proposed doing in the way that you think makes it as clear as possible that the rule is as you say it should be. And that for some of the other changes that you may think are more complicated or more technical, or you've got some questions about the law of unintended consequences, you, with my apologies to Ms. Berman, you task her committee and the Rules Committee to go back through these comments, because I do think there's a lot of interesting ideas there, and I don't envy your task in trying to go through all of that and decide which to take in the next 22 days. So we would suggest, if you have any concerns about that, implement the rule you've proposed, make clear when it applies, make other changes that improvements that you think you can make, and beyond that, let Ms. Berman and her committee do their job, because I think there are other good changes suggested, but the timing of this is critical, and we wouldn't want to delay implementing the new summary judgment standard. And if the court has no further questions, I really thank the court for taking this issue up and for the time.
Well, thank you, Mr. Edson, and I want to again say thanks to everyone who has participated in the oral argument today, and for your comments, and for everybody else who has participated in this process and provided input to the court. We are very grateful, and we know, as has already been acknowledged, that a lot of people have done a lot of work on this, and the court is deeply grateful for it. And with that, the court will now stand in recess for about 10 minutes before we take up the next case on our docket. the case of Noetzel versus the state. Counsel for the appellant.
Thank you very much, Mr. Chief Justice. Members of the court, I'm Baya Harrison, court-appointed counsel for the appellant, Mr. Barry Noetzel. I've asked to reserve 10 minutes if you would allow me for rebuttal. Your honors, this is a direct appeal of a March 25, 2020 final judgment of guilt of first-degree murder and other offenses and a sentence of death plus other sanctions. The facts in the case, Your Honor, are really not in dispute. Mr. Noetzel was serving a life sentence for robbery. He and co-defendant Jesse Bell murdered another inmate by stabbing and choking him to death. Mr. Noetzel and Mr. Bell then attacked a prison guard who fortunately survived. Mr. Noetzel waived his right to counsel, waived the jury, pled guilty, and was ultimately sentenced to death. Mr. Noetzel expressed a desire on several occasions to be executed, but he did not stipulate to the existence or the sufficiency of aggravating factors. Your Honor, the issue in the appeal is as follows. Whether the trial court erred in failing to conduct an adequate Feretta inquiry, and especially to reconsider Mr. Noetzel's competency to waive counsel and represent himself after it was revealed prior to the Spencer hearing that he suffered from paranoid schizophrenia. Florida Rule of Criminal Procedure 3.111, on the one hand, protects a defendant's constitutional right to self-representation, except when the defendant has a severe mental illness that interferes with the ability to conduct trial proceedings by oneself. And schizophrenia is recognized in the case law as a very severe mental illness within the meaning of that rule. As far as the chronology of things is concerned, Mr. Noetzel filed a pretrial motion to discharge his attorney and to represent himself. And the trial court conducted what we have to admit was based upon what the court knew, a fair Feretta hearing on the motion during the month of January of 2020. The court explained the dangers of self-representation, but made only a very limited inquiry into Mr. Noetzel's mental status. Mr. Noetzel only admitted that he suffered from depression and that he was prescribed psych medication. He noted that he was refusing to take this medication so that he could remain clear-headed. It was at this point, Your Honor, that defense counsel, before defense counsel was discharged, defense counsel asked the court to appoint an expert to determine from a scientific and medical standpoint whether or not Mr. Noetzel was competent to waive counsel. The court, however, disagreed, denied that request, went ahead, completed the Feretta proceeding, accepted Mr. Noetzel's guilty plea on all counts, including the conviction for first-degree murder. Thereafter, the court indicated out of an abundance of caution, the court appointed Dr. Umesh Matre, who was a medical doctor, a psychiatrist, to determine Mr. Noetzel's competency to proceed. And here we note an important distinction. The appointment of Dr. Matre was not to determine anything other than the competency to proceed as opposed to competence to represent himself. Dr. Matre filed his report in February of 2020. It found Mr. Noetzel competent to proceed and included a finding that Mr. Noetzel had a prior diagnosis of bipolar affective disorder. And this is a very important finding from the doctor. There was then, it followed in February of 2020, a penalty phase trial. The Attorney General has indicated that he didn't think it was really much of a trial, but it actually was. During this penalty phase proceeding, the state called 5 witnesses and introduced several documents and other exhibits into evidence. Mr. Noetzel even cross-examined some of the witnesses. He even objected to one exhibit, and he introduced Dr. Matre's report into evidence as mitigation. So this was clearly a jury trial, and according to Rule 3.111, a defendant who represents himself must not have the kind of mental issues that Mr. Noetzel had in order to do that. Things came.
Counsel, I'm sorry. Are you advocating adoption of a per se rule?
No, sir. No, Your Honor, I am not. I think that's a very good point. I don't think that this case justifies a decision that simply because Mr. Noetzel was diagnosed as a paranoid schizophrenic, that this was the end of the story and the judgments and sentences would have to be vacated. On the contrary, as we indicate, there was a later PSI order, and in the pre-sentence investigative report, this diagnosis of paranoid schizophrenia came out. And it is the way that the trial court handled that is of concern. And remember, Mr. Noetzel had already been determined to be bipolar. You combine the bipolar disorder with schizophrenia, and under so much of the case law in Florida, this would almost per se not allow this gentleman to represent himself. But to kind of anticipate your question, I don't think it was conclusive. What we are contending is that the trial court had a continuing obligation to conduct a Feretta inquiry into Mr. Noetzel's mental status once the schizophrenia diagnosis came to light, before allowing Mr. Noetzel to continue to represent himself. In other words, the trial court should have taken this diagnosis to include the bipolar findings, impaneled or appointed experts to look at the big picture from a scientific and medical standpoint, and advise the court accordingly. This didn't happen. The trial court instead simply gave this diagnosis slight weight and went ahead and proceeded to sentence Mr. Noetzel to death. And that's where
Counsel, I'm sorry to interrupt you. So how should we view the fact, though, that so in the PSI, the defendant kind of self-discloses this prior diagnosis? There doesn't seem to be any real sort of detail added to that. He was, though, in this proceeding at the direction of the court evaluated, and there wasn't any indication there that he had any mental illness that would prevent him from waiving counsel and that. So I mean, how do you put those two things together as far as how should we look at that?
Your Honor, Dr. Matre did not examine Mr. Noetzel to determine whether he had the ability to represent himself, only whether he was competent to proceed, and that is primarily to assist his counsel, even though the judge had dismissed his counsel. And so, as I was asked earlier, I'm not saying this was a slam dunk. It was not a slam dunk for the defendant. It was not a per se basis to vacate the judgment and sentence. But at that point, the trial judge had an obligation. There's a continuing obligation for trial judges to consider matters related to Feretta, and the trial court should have appointed experts, gotten a scientific evaluation of this situation, given both sides an opportunity to be heard, and then if the diagnosis turned out to be invalid, proceed with sentencing. But if it turned out that the diagnosis was valid, I mean, the judge found it to be valid, but but if it was found to be scientifically valid, then I think this would be a failure to conduct an adequate Faretta proceeding, and the judgment and sentence would have to be set aside. With this in mind, Your Honor, I will stop now unless there are further questions, and reserve my time for rebuttal.
All right, counsel for the state.
Mr. Chief Justice, and may it please the court, my name is Jason Rodriguez, Assistant Attorney General for the state of Florida. In my time before the court, I will explain why the trial court permitted appellant to exercise his constitutionally given right to represent himself. I want to jump right into issue one, because it seems like from what appellant has argued, the main issue that's going to be reoccurring in this case is the failure to make a finding under Rule 3.111D3 that his mental status was impaired to the point that he could not represent himself at trial. And we can cut this part of the argument without a great deal of legal analysis by looking at the trial court's explicit findings on the record. So I'll direct your attention to the record at page 300, and it goes through page 301. The trial court has reviewed Dr. Matre's report. The trial court turns to appellant Noetzel and says, I'm considering this report on two things: your ability to represent yourself and your competency to proceed. Appellant Noetzel says he has no objection to the trial court considering the report for those dual purposes. And then the trial court makes this explicit finding: there's no indication of any sort of mental infirmity or defect that would prevent you from doing so. In context, speaking of proceeding and representing yourself. So to the extent that an Edwards type finding is required under Rule 3.111D3 under these circumstances, the trial court made that finding. And there was no objection and an express waiver by appellant Noetzel to the evidence he utilized to make that finding. So that's an easy way for us to redirect this situation away from even the law that's involved here and whether a finding was required. The trial court did exactly what appellant argues he should have done in making this finding. There was also, appellant argued that there was a limited inquiry into the Faretta and the medication that he was taking. On page 504 of the record, through really page 506, the trial court asked appellant if he suffered from any mental illnesses or diagnoses that would impair his self-representation. Appellant said only depression, and that does not impair him. So the trial court's inquiry was as complete as it could have been with the defendant, with the information the defendant gave. But the trial court then took it a step further. He appointed Dr. Matre to evaluate appellant. Dr. Matre listed 3 ailments that appellant suffered: bipolar disorder, antisocial personality disorder, and depression. Of note, nothing in Dr. Matre's report indicated paranoid schizophrenia. The only evidence in the record of paranoid schizophrenia at all is a offhand one-sentence comment in the PSI that contradicts what appellant Noetzel had told the trial court at its earlier Faretta colloquy. So in light of this, just from a factual standpoint, the facts do not support the contentions that appellant has raised. The trial court appointed an expert who determined he was competent to waive counsel and enter a guilty plea. And under the United States Supreme Court case of Godinez, that was all the trial court needed to do to determine competency. Indeed, Godinez goes a step further in footnote 13 and says competency is not required, a competency determination is not required, except when there's reason to doubt the defendant is competent. And in this case, both the trial court and defense counsel, in speaking to the trial court and asking for an abundance of caution evaluation, said they have no reason to believe that this defendant was incompetent to proceed. So the trial court went above and beyond what's required of him under the law in appointing this expert. It was not required to do so. But what appellant has argued on appeal, that this expert was only to evaluate ability to stand trial and not competency to represent himself, this argument is flatly contradicted by the United States Supreme Court case of Godinez, where the Supreme Court held a capital defendant who was going to a penalty phase was competent to represent himself when he could make that decision at the plea phase. If he was competent to stand trial, he was competent to represent himself. The inquiries are identical, and the majority rejected what appellant has argued in this appeal, and Justice Blackmun relied on in his dissent in Godinez. Justice Blackmun said, quote, even Moran, the defendant in Godinez, who pleaded guilty, was required to defend himself during the penalty phase of the proceedings, and a defendant early incapable of conducting his own defense cannot be considered competent to make such a decision. So what the Supreme Court did in Godinez contradicts appellant's position here. Moran actually went to a penalty phase in Nevada. It was a 3-judge panel that found aggravators and mitigators, which is exactly like this case where appellant Noetzel appeared at a penalty phase before a single judge because he waived a penalty phase jury and introduced evidence, cross-examined state's witnesses. Continually throughout this record, there is no indication that he was incompetent. He represented himself for a pro se individual to the extent of his knowledge and ability well. There was no indication at any point of incompetence. Moving very quickly to the second point, that the chief inquiry for this court on the paranoid schizophrenia diagnosis is, does a paranoid schizophrenia diagnosis provide reasonable grounds to reconsider the competency finding that the judge had previously made? And in this case, where it is a self-reported, non-firm diagnosis that was not in any of Dr. Matre's reports, not in DOC's records, that was not reasonable grounds to reconsider the trial court's prior competency determination. There was no per se reversible or fundamental error in the failure to hold an additional Feretta hearing in this case. Your Honors, unless this court has any further questions, I'll ask this court to affirm the judgment and sentence below and yield the remainder of my time.
Thank you, counsel. Rebuttal.
Very briefly, Your Honor, because I think I've made the points that I felt needed to be made as to the paranoid schizophrenia diagnosis. The judge himself, the trial judge himself, found this diagnosis to be credible. I agree that it was provided by Mr. Noetzel himself during a PSI. You've got to remember, Mr. Noetzel was trying to kill himself. Mr. Noetzel didn't want any relief. You can't expect him to have advocated for his survival under those circumstances. But the law is very clear: when you combine a bipolar affective disorder with paranoid schizophrenic problems, then under the law, the case law, at the very least, the trial judge needed to reevaluate his earlier decision and act accordingly. Your Honor, that's all I have in this regard on rebuttal, and I thank the court very much. Unless you have further questions, I will conclude.
All right. Well, we thank both of you for your arguments in this case today. That is the final case on the court's docket. So this session of the Florida Supreme Court is now concluded.